Welcome to CM Guide podcast series. Here in the deep dive, we're your shortcut to being well-informed, diving into the sources you provide, and pulling out the most important insights. Today, we're cutting through the complexity of contract termination, specifically how a contractor can pull out of an agreement under the FIDIC Red Book. We'll uncover the key entitlements, the precise steps involved, and crucially, what's new and different between the 1999 and 2017 editions. It's a vital, often high-stakes area in construction, and we'll be drawing our insights directly from the FIDIC Red Book 1999 and 2017 editions themselves, plus some expert commentaries. So before we get into the, let's say, the nitty-gritty of the how and when, why is understanding contractor termination so profoundly important? In the world of FE contracts, what's truly at stake here for you, whether you're a contractor, maybe a project manager, or anyone involved in these massive agreements?
That's the perfect place to start. Because termination isn't just some legal checkbox. It's the nuclear option in a contract, really. As commentaries on these contracts often say, the legal and practical consequences should be considered in depth before notice is given. You really can't take this step lightly. See, FIDI contracts, the Red Book concluded, they're fundamentally built on this idea of balanced risk sharing.
Right, balanced risk.
Exactly. So both parties have very clear rights, but also obligations. And for a contractor, the ability to terminate, it isn't just a right. It's a critical protective shield. It's designed to allow them to exit an agreement when certain non-negotiable conditions, things meant to protect their interests, are fundamentally breached by the employer.
Okay.
Think of it as the ultimate safeguard for your project's viability and, frankly, your company's financial health.
That makes perfect sense. It's about protecting your interests when the other side basically fails on their end of the deal. So if a contractor finds themselves in that kind of tight spot, maybe facing an employer's breach, what are the actual triggers? In the 2017 Red Book, what gives them the power to say, right, that's it, enough is enough? When can they actually pull the plug?
Okay, good question. The 2017 FIDI Red Book, specifically under Clause 16.2.1, it lays out a very comprehensive set of circumstances, a whole list, really. But the key thing to remember is that for most situations, it requires what's called a notice of intention to terminate. That gives the employer a chance to, fix things.
The cure period, sort of.
Exactly. But for some really serious breaches, it allows for an immediate notice of termination, no waiting period.
Okay. So what are some examples?
Well, let's look at some of the most common and critical grounds. One of the biggest red flags for any contractor is the employer's financial stability or lack thereof. So if you've given a suspension notice, maybe because payments are late, and the employer then fails to provide reasonable evidence of their financial arrangements within 42 days, well, that's a direct trigger.
Makes sense. You need to know they can actually pay.
Precisely. Then there's the issue of payment certificates. If the engineer drags their feet and fails to issue a payment certificate within 56 days of getting your statement and all the supporting documents.
56 days.
56 days. That's a ground for termination. And even if the certificate is issued, if you don't actually receive the money you're owed under any payment certificate within 42 days after the official payment period,
right,
that's another clear reason to terminate. It's all about protecting your cash flow, ensuring you get paid for the work done.
Of course, cash flow is king.
Absolutely. Then you get into the employer's compliance with decisions. So if the employer fails to comply with a binding agreement, or maybe a final determination from the engineer, or even a decision from the DAA, that's the Dispute Avoidance Adjudication Board.
Okay.
And this failure amounts to what's called a material breach, you have recourse. Or even more broadly, if the employer just substantially fails to perform any of their obligations, and it constitutes a material breach. We're talking fundamental breakdowns here, not just minor slips.
Got it. Material breach. It sounds like it could be open to interpretation sometimes.
It can be, yes. And that's where good record keeping and clear evidence become vital.
Okay, what else?
Time-sensitive issues can also be triggers. For instance, if you don't get the official notice of commencement date within 84 days after receiving the letter of acceptance.
84 days. Wow.
Yeah, that's a basis for termination. Or, here's a big one, if the employer tries to assign the contract to someone else without your required agreement, that often allows for an immediate termination notice because, well, it fundamentally changes who you're actually working for.
Right, that's huge.
Definitely.
Yeah.
And finally, there are situations that are, let's say, immediate game changers. A prolonged suspension affecting the entire works that can lead straight to an immediate notice. Or, critically, if the employer becomes bankrupt or insolvent. That's an immediate termination ground.
Makes sense.
And perhaps the most severe, if the employer is found, based on reasonable evidence, to have engaged in corrupt, fraudulent, collusive, or coercive practices.
Ugh.
Yeah, these are the no warning, straight to termination scenarios.
That is quite a list. It really highlights how many specific scenarios are covered. But practically speaking, for a contractor out there, things moving fast. How difficult is it to gather that reasonable evidence? You mentioned corrupt practices, or defining a material breach that's substantial enough. Are there common pitfalls there? Things contractors often stumble on when trying to prove these grounds.
That's an excellent point, and it really gets to the heart of the practical challenges. While the grounds themselves might seem clear on paper, proving them, especially the more subjective ones like material breach or corrupt practices, that can be demanding. Commentaries really emphasize that the burden of proof is squarely on the contractor. You need robust evidence.
Right.
For financial arrangements, it's about documented proof they didn't provide it. For a material breach, it often involves showing a pattern of noncompliance or maybe one single failure that had a huge impact. The pitfall. Often it's insufficient documentation, or sometimes not giving adequate notice where that cure period is intended.
Jumping the gun.
Exactly. Contractors sometimes act without ironclad evidence or without meticulously following the notice procedures, and that can completely invalidate their termination attempt down the line. It's a classic case of measure twice, cut once,
Absolutely. So knowing when you can terminate is step one. But step two, the how. That sounds just as critical. It's not just sending a quick email, is it? What are the crucial procedural steps FIDI lays out to make sure a contractor terminates properly and, importantly, protects their entitlements?
Precisely. The how is just as vital as the when. And the 2017 Red Book provides, well, significantly more detail and clarity on notices and communications compared to the old one. Think of it like a detailed roadmap. Commentaries outline a pretty clear 5-step process.
Steps, okay.
Yeah. First, establishing the grounds, which we just talked about. Second, the actual termination procedure itself. That's where the crucial notices come in. Third, what happens? After the procedure is initiated, the immediate actions needed. Fourth, the valuation procedure for work done. And finally, the payment procedure. Each step is designed for fairness and clarity for both sides.
Okay, so about those notices.
Right. A really significant aspect in the 2017 edition, you find it in clauses 15.2.2 and 16.2.2, is this explicit requirement to describe the matter. That means the specific default in your termination notice.
Describe the matter.
Yes. And it's not just, bureaucratic wording. Commentaries explain that for most defaults, this notice period serves as a final chance to remedy the breach. So you can't just send a generic notice saying, we're terminating because of breach of contract. You must specify the exact default, like failure to provide financial evidence for period X, or repeated failure to issue payment certificates for months Y and Z. Be specific.
And if you're not specific enough?
Well, the consequences can be fatal to your termination claim, especially where that cure period is intended.
Well,
imagine you just say breach of contract. The employer could easily argue they had no idea what specific issue they were supposed to fix. Now, it might be less critical if the default is incredibly obvious or totally beyond repair, like, say, the employer goes into liquidation.
Sure.
But generally, you can't introduce new reasons for termination after that initial notice. If you discover another major breach later, you typically need to issue a brand new notice for that specific issue. It's all about clear communication and giving a fair shot to fix the problem where that's applicable.
That level of detail for notices is really interesting, especially the final chance to remedy part. It sounds like FIDI is really trying to push parties towards, fixing things before it all falls apart. You also mentioned the engineer's role earlier. How does that play out in this termination process, especially with disputes or these deemed rejections you talked about?
Yeah, that's a critical point. Under the 2017 Red Book subclause 3.7, the engineer's role is much more explicitly defined now. For example, if the engineer fails to agree or determine a claim within 42 days, that claim is automatically deemed rejected.
Automatically.
Automatically. It's a big shift because it means the engineer's inaction has a direct consequence. No more limbo. And maybe even more importantly, if it's a matter the engineer was supposed to agree or determine and they just fail to act, that matter is immediately deemed a dispute.
Okay.
And that dispute can then be referred by either party Straight to the DAB, the Dispute Avoidance Adjudication Board, for a decision. You don't even need a prior notice of dissatisfaction.
So it speeds things up.
Exactly. It streamlines the path to dispute resolution and stops claims just languishing indefinitely. It's a real push towards efficiency and hopefully avoiding bigger blowups.
Okay, so let's say the contractor has navigated all those intricate steps they've terminated correctly. What does this mean financially? Boots on the ground, what are their actual entitlements, and how does the payment process work once the contract's been pulled?
Right. This is where the contractor's protection really comes into focus. The contract is very clear. Termination shall not prejudice any other rights of the contractor, under the contract, or otherwise.
That sounds important.
It is. It's a powerful statement. And the 2017 Red Book includes very detailed valuation and payment mechanisms as part of this termination process. The goal is to ensure you're not left high and dry. One very clear entitlement, if the employer has delayed payments leading up to this, is what FIDA calls financing charges compounded monthly on the amount unpaid during the period of delay. That's spelled out in subclause 14.8.
Compounded monthly.
Yes. Not just simple interest. It's compounded, and it kicks in right from the expiry of the payment period. So if your payment certificate was due on the 10th and you don't get paid, those charges start racking up immediately. It's a pretty powerful incentive for employers to pay on time, wouldn't you say? And a critical recovery tool for contractors.
Absolutely. What else?
Well, another significant entitlement, which comes up in various situations where the contractor incurs costs because of the employer's failures. Let's say the employer fails to give access to the site on time, causing delays and extra costs.
Okay.
The contractor can be entitled to payment of cost plus profit.
Cost plus profit. How does that work exactly?
So cost basically covers all the expenditure you reasonably incurred in performing the contract. That includes things like taxes, overheads, similar charges, but crucially, it excludes your profit. Cost plus profit adds a predefined percentage for profit on top of that cost. Often, that percentage is stated right there in the contract data.
And if it's not?
Good question. If it's not specified, it defaults to 5%. So this ensures you're made whole, not just for your expenses, but also for a fair profit margin. It protects your bottom line even when the project goes sideways through no fault of your own.
So you're not just getting your expenses back, you're getting compensated for the business opportunity too, in a way.
Precisely. It recognizes that you undertook the work expecting to make a profit.
That's a pretty strong safety net. Now, we've focused a lot on the 2017 Red Book, which is great. But for many people listening, they might have worked with the 1999 edition for years, maybe still are on some projects. How do these contractor termination provisions compare? Between 1999 and 2017, what's genuinely new and what's perhaps just been refined or clarified?
That's a really important comparison. The 2017 Red Book definitely represents a significant evolution from the 1999 version, particularly in its drive for enhanced clarity and detail. Just quantitatively, the 2017 edition is noticeably more comprehensive. It has 21 main clauses, 169 subclauses, compared to 20 main and 163 subclauses in the 99 version.
Okay, a few more clauses.
Right, but that difference isn't just about length. It signals a much more detailed approach, trying to anticipate and address potential issues more thoroughly. A major difference, and we touched on this, is how 2017 clarifies the ambiguity around notice periods that existed in the 1999 contracts.
The cure period thing.
Exactly. The 99 version was often quite vague about whether a termination notice automatically implied a cure period. That led to a lot of disputes, as you can imagine. The 2017 Red Book, as we said, explicitly requires describing the matter and usually provides that final chance to remedy the breach. This specificity is really aimed at reducing disputes by making the rules clearer from the outset.
Makes sense. Less room for argument.
Hopefully. It forces parties to be precise and gives that defined opportunity for fixing things. The engineer's role, too, has significantly evolved. The 2017 edition puts a greater focus on the role of the engineer. While the engineer was always crucial, in 2017, they're explicitly expected to act neutrally in agreement and determination processes. That's under subclause 3.7. Yes, an emphasis on neutrality. Combined with those clearer procedures for deemed determination that we discussed, it aims to streamline claim resolution and proactively prevent disputes. It puts the engineer much more squarely in an impartial, dispute-avoiding position.
Okay.
And building on that, the 2017 edition really strengthens the mechanisms for dispute avoidance. It clearly separates simple claims from becoming full-blown disputes much earlier. You see this perfectly reflected in the name change, right? From the Dispute Adjudication Board, the DAB, in 1999.
To the Dispute Avoidance Adjudication Board, the DAB, in 2017.
Exactly, the DAB. The intent is clearly to resolve issues earlier before they escalate to expensive arbitration or litigation, saving time, money, relationships. It's a proactive rather than reactive approach to conflict.
That seems like a very positive shift.
It is intended to be. And just as a final point on this comparison, it's worth remembering FIDIC's own perspective. Commentaries highlight their overarching concern about people modifying their standard general conditions without fully understanding the implications. They genuinely worry that unauthorized changes might mess up their core principles, like that fair risk distribution we talked about, and could even potentially threaten their trademark.
Interesting.
Just underscores why it's so important to understand and correctly apply these standard forms. They're meticulously designed to maintain a very delicate balance. Deviating without careful thought can easily shift that balance and lead to all sorts of unforeseen problems.
This deep dive has definitely shown a light on the complexities, the nuances, and those significant changes in how contractors can terminate under the FIDIC Red Book, especially that shift from 99 to 2017.
Indeed it has. And it leaves us with a thought, perhaps. Given this increased specificity, all this emphasis on clarity in the 2017 Red Book, how might this greater detail really impact dispute resolution in practice, particularly around contractor terminations? Does having a more prescriptive framework definitively lead to fewer conflicts? Or could it, maybe inadvertently, create new complexities, more hoops to jump through for compliance, perhaps leading to more technical arguments rather than focusing on the substance of the dispute? Something to consider.
That's a great question to ponder, a really provocative thought. Before you go, please don't forget to share, like, or subscribe. Also have a look at other episodes and visit CM Guide website for better insights on this topic.